Thank you for joining us today. My name is Jessica Reynolds, and I'm the Director of the Office of Downtown Development with the Georgia Department of Community Affairs. The webinar you're about to view was previously recorded in January of 2022 with Christy Barnes, the Director of Legal Services with the Georgia Department of Community Affairs. The reason that this webinar exists is I had the pleasure of hearing Christy present this to our agency staff as a refresher and reminder for open records compliance. And with so many of our Main Street and downtown development authorities needing to adhere to what we call these Georgia Sunshine Laws, open records, open meetings, I thought it would be a great opportunity to do a refresh on a topic that we don't talk about very often, but that Christy has a way of making so entertaining and so engaging. So this is that webinar. Enjoy. All right, so let's get started. Thank you again, Christy, for being here. I know I've kind of given the context and some of the background of how we got to this point, so I'm going to turn it over to you. So if you could introduce yourself to our group, give us a little bit of background and history as to how you got to DCA and how you got here, and then I'm just going to let you do your thing.
Okay, that sounds great. Thank you so much, Jessica, for inviting me today and for your kind words. I truly enjoy working with the great people of DCA, and the great work that we do at the agency is a reflection of that. I'll just tell you a little bit about me. I'm the Director of Legal Services at DCA. That means I hold the General Counsel role for the agency. Prior to that, I'm originally from Mississippi, and I went to law school in Louisiana. I started out in banking, doing corporate law for a large bank there, and quickly was drawn to public service when Hurricane Katrina hit and devastated that region. And there was just such a large need for support in the area to get people some stable housing and then resources so that they could return home and rebuild their own homes. So I was drawn in to service from that initiative, and I've served in lots of different capacities since then in state and federal government. And at DCA, I joined the team almost 10 years ago. Well, it'll be 9 years in February. I still can't believe that. It seems like this time is just flying by, but when I joined the team, I was the legal consultant in the housing division, and then I was able to matriculate into the general counsel role. So I enjoy it. I enjoy it very much. And in this role, I'm often required to tell DCA staff about open records requirements and communication tips. So this is really in line with what we do at the agency, and I'm happy to share a few tips today with the team. So I will go ahead and dive right in. I want to start with our presentation by saying, usually when you hear presentations about the Open Records Act, it will be very, very detailed about the elements of the act. I think today what we'll do, though, is instead of a deep dive in that way, we will be a little bit more conversational, and we'll talk about the Open Records Act from the perspective of how we experience the Open Records Act as public service employees and those individuals who are connected to state employees. But I do want to start at the very beginning, because there is a possibility that there's someone who's very new to this environment and they may not know. So what is the Georgia Open Records Act? This is the basis of what we're discussing. The Georgia Open Records Act is a law or a set of laws that will provide access to records in government at all body levels of government in Georgia. So as we go through this, there are three things I want you to remember about the Open Records Act. And so we're on number one, and that's the purpose. The first thing you should remember is that the purpose, as Jessica mentioned before, the purpose is really transparency in government. And it's also to allow public access to records. And this is in the Georgia Code. So if you ever need to go back and see all the details of the Open Records Act, you can do a quick Google search and type in OCGA 501870, and you can see all of the requirements of the Open Records Act in one place. But the very first thing I want you to remember is it's public access to records. The next item that I want you to remember from this presentation is the Open Records Act is a document access statute. What that means for us is the requirements under the Open Records Act do not require that we answer questions, and we're not required to create brand new records that aren't already components of what we do. So I want to explain that a little bit deeper. Of course, as government officials and as individuals who work with government bodies, we answer questions all day and in our operations. But if someone were to make an open records request that was in essence just a list of questions, that's not the purpose of the Open Records Act. The Open Records Act is intended to provide documents and access to documents. So merely responding to questions doesn't trigger the requirements of the Open Records Act, and merely asking questions would not also obligate us to respond as if this was an open records request. Similarly, when we're talking about the creation of records, there are often times where the information is something within our purview, but it may not exist in a specific format or in a specific type of record that's being requested. An example that I like to give here is there's sometimes you may be asked for financial records pertaining to specific types of projects, for instance. If you have a composite financial document that's all projects that are being maintained by your organization or your agency or your local government, and the response to this question is a component part of that request, then that entire request can be provided. But what was not required is that whoever is responding to the request, would have to go in and massage that record or pare it down to fit narrowly to the request that has come in. We're not required to do that at all under the Open Records Act, and I like to make sure that we point that out as our second level of item that we want to remember about the Open Records Act. I have a little note here that I also like to take a little time to explain. At DCA, I like to point out that we're not required to make available records that are subject to attorney-client privilege or are an attorney's work product and therefore has privilege, or anything else that falls under an exemption status under the Open Records Act. It's important that you understand who would create an attorney-client privilege within your organization. The example that I like to explain at DCA is that even though I am the agency's general counsel, I don't create an attorney-client privilege because I don't represent the agency on legal matters outside of the agency itself. So the legal representative for our state agency is the Attorney General's office. So there cannot be any attorney-client privilege or attorney work product privilege that doesn't exist unless there is an attorney from the Attorney General's office involved in that matter and who's overseeing that matter. So I would just encourage you to understand who your attorneys are and who can provide that type of privilege. So when you are communicating with your attorneys, you know that those items could potentially be protected from disclosure and exempt from disclosure because they are attorney-client privileged communications or attorney-client work product privilege. Exceptions may apply. So you want to talk to your attorney representatives to make sure you know all the details of how those privileges work, but understanding who your attorneys are is probably the first step in identifying that exemption. The third thing that I want you to remember is really intentionally number 3, because it's the response time frame, 3 business days. Under the Open Records Act, we have to produce our responsive records, our initial response letter, within 3 business days after we receive the request. The obligation under the Open Records Act is truly that we are going to be as deliberate as possible in responding to those requests. And so that 3 business day time frame, if the records are available and we can provide them within 3 business days, we should make every effort to do that. If by chance there's some extenuating circumstance or some factor regarding the request that would make 3 business days unreasonable or illogical or something that just cannot be accomplished, we should minimally respond to the requester and let them know we received the request and that we think we might have some responsive documents, and then also providing a timeline that would support what's more feasible for you to actually get these documents produced to the provider. So that's our obligation. And that's the third thing I want you to remember about the Open Records Act, and that's 3 business days. So we've talked a lot about the Open Records Act, under the Open Records Act, about records. So I want to dive a little bit into what exactly is a record. So if you've seen several open records trainings or presentations before, please just indulge me for a few minutes to go through this list a little bit, because I want to talk about how broad the definition of public record is. And I also want to point out the fact that we're really talking about the content of the record and not necessarily the medium. But a public record is defined in the Georgia Code as 501870B2, and it includes things like documents, papers, letters, maps, any computer-generated reports or information, or any information that's being produced, maintained, prepared, or received by the agency or the person on behalf of the agency in furtherance of any type of government use. So it could be for current government use, past or future government use, but all of those types of information that are furthering some government use is considered a public record. So there are some exemptions. If you have a moment and when you're reviewing any request for records, you should take a moment to look at the exemptions just to be sure that you're providing information that's required to be disclosed. The exemptions are found in the official code of Georgia, annotated at 501872. A quick Google search with just those words will bring up the exemptions list for you. There are 48 exemptions to public disclosure, and they're pretty specific. So you want to make sure that you know what they are, and that once you review that list, if there's something that's exempt from public disclosure, you either redact it from the record or redact the record if individual redactions isn't possible. And then you always want to give the reason that those items were being withheld. So if it's an express exemption, for instance, there is one that we do not disclose home addresses or personal contact information for public officials and public staff. If that is the request and that's what we are redacting, then you would want to cite that when you issue your response. You've requested all the records from HR over the last 6 months. It included one report that had personal information for all of our staff. That information was redacted as it relates to this exemption. And that way, if anyone ever challenges your responsiveness and and the completeness of your response, then you have on record what you did and why you did it. Okay, so we're going to jump into some frequently asked questions. One of the questions that I get at my agency, and I'm sure it might come to your mind often, is, are emails records? I mean, is an email a record? And the answer to that is yes, they often can be records. Because remember, we said earlier, records are not determined by the medium, but really the content. And as we've worked in a virtual environment, and as we start to continue to work in electronic spaces, it's quite often that we use emails to move work forward and to document actions and work products in that way. So it's possible that emails are records. How we see this at DCA, we often get requests for emails from date ranges for specific individuals, but also for specific types of individuals. So anyone in executive leadership who has any emails about, I'm going to say, give an example, let's say water projects that would happen in the state over the last year. And then we have to search the emails for those types of things. So oftentimes they're keywords that you can plug in, and that will come up. And understanding what's in the email as records is important. For our perspective, at the point that someone asks for emails, that's not the time for us to determine if it's a record or not. We will talk a little bit more about how you review your emails to determine whether you should be holding on to them or whether you should be releasing them and maintaining them because they are records. And we'll get into that in a little bit. So then there's another question: can I just choose a day and just delete every email I have, and then I just never have to worry about producing them? And wouldn't that be lovely if we could just do a big delete all? There was a movie like that where I think maybe it was God Almighty. Definitely it was Jim Carrey, where he was playing God and he did a delete all on all the requests, thinking that was going to magically resolve his life. But it did not. And it would not for us either. It would cause us a lot of problems if we just delete emails without doing the appropriate access and the assessment to determine whether or not those emails have records included in them. We could not only be violating the Open Records Act, but most often there are retention requirements connected to the work that we do. If they're federal funds, there may be federal timelines that we have to maintain certain records. And if they're state funds, they may have the same type of timelines attached. So you want to make sure you're reviewing the content of your emails to ensure that there isn't some type of requirement to retain those emails for a longer period of time than you deem that email to be useful to you. The next question that is frequently asked is, what about text messages and chat messages? Are those records? So earlier we mentioned, and I'm kind of a broken record here, but it's not the medium, but the content. So if your agency or your organization tends to move towards doing a lot of work via text message or chat messaging, or if you're sharing reports, you're creating groups and you're working in that area, you could have chat messages and text messages that are equivalent to reports. There's also just the general communication request. So you may have someone to say, I need to see everything, all communications that Jessica Reynolds sent out in the last 3 months. That would include every form of communication, including text messages and chat messages. So we want to be aware that our text messages and our chat messages are not a safe space where they're never going to be subject to public disclosure. They might be, depending on how the request comes in and when and what they're looking for. Another question that we often get, because we're often looking for ways to move our work forward very quickly and be as efficient as possible. So we might start to try to synchronize our platforms. So I get this question a lot: can I use my personal email account for work purposes? And really, at DCA, we frown upon that generally. And the reason is, it's very risky. If you're using your personal email account for work purposes, this could open your entire personal email account to be subject to open records. And I know none of us intend to have our personal email correspondences be something that can be publicly available. So in that regard, we want to make sure that we're not intermingling our personal account and our work account. The recommendation is always to use an official email account. Make that your sole way of corresponding via email. And so anytime a question arises about how work has been done or any record that might exist, there's not a risk that a record lives in your personal email account that would subject your entire personal Gmail, Yahoo, Hotmail, AOL account to review. So here's another frequently asked question. Can I just, when I'm reviewing these responses, if I look at it and I know this really isn't what the requester is trying to get to, or really something in the result is embarrassing to me, can I just omit that? Because it's not really the essence of what they were looking for anyway. And the answer to that is you should not do that. You should really provide any and all responsive records to a requester, unless there's an exemption for it under the Open Records Act. Where we see this most frequently is when there are keywords that are given. So if someone makes a request, and I'm picking on Jessica because I know she won't mind, but we don't get requests for Jessica's emails, just to be clear. But if someone were to say, I would like to request all of the communications that Jessica has had with any mainstream related program, and I want to use these keywords: Jessica Reynolds, Main Street, economic development, community development, and we'll use another one. We'll say federal funding under the FFCA. Some keywords that they've given us. We then can perform a search of emails to determine what comes up as a result of those. But at the end of the day, if Jessica has in her emails 17 emails with me where we're going back and forth about where we're going to have lunch and what we're going to do, when we're going to go, and we're trying to make lunch plans for one specific day, and it looks like that's all we did that day was talk about lunch, that might be something that she doesn't want to share. But if it comes up as a result of a request that has come to us, it is not appropriate to choose to unilaterally withhold those types of results. And so we'll talk about how that plays out in other areas if you have additional questions about it, but be very careful about omitting anything from a GORA response that's not expressly listed as an exemption under the Open Records Act. I have a few best practices for GORA compliance generally. One of the best things you can do is attend trainings like this. And then, because it's not something that's always front of mind, especially if this isn't your primary responsibility within your organization, you might not have the GORA rules at the forefront of your mind all day, every day. But if you're regularly training, annually, every 6 months, something that refreshes your memory will be very helpful to making sure that you can comply with the Open Records Act. You should also know how to access your resources. Under the resources category, the three things I think you should know is where to find the Open Records Act. You can do a quick Google search and it'll bring you to it. You can also find it in the Georgia Code if you have LexisNexis or Westlaw or some type of platform like that gives you access to legal research. You can pull it up there, but it's very easy to find. It's also maintained by the Attorney General's office. So if you ever want, I shouldn't say if you ever want, they used to produce mass produce these small red booklets for the Sunshine Laws, and we could have them as a physical resource. But if you're looking for something like that, I would say the Attorney General's office is where you would search to request those literature booklets that would have the Open Records Act and Open Meetings Act rules in one place for you. And then also retention schedules, knowing how you are required to review your records to determine how long you have to maintain them and in what situations you have to do that is very important. At DCA, we have a records management office that helps us with our retention schedules. They update them regularly and remind us of them, but because we have both federal and state funds, it can be very, very difficult to just know off the top of our heads what type of content applies to which retention schedule, but we have resources within our organization to help us identify that. And I would say understanding what your retention schedules are and where your resources are for that would be important. And that's kind of segueing into the third bullet here. Know how you can get help quickly if you have questions about open records within your organization. Usually there's an agency point of contact that makes sure all of the elements of GORA is being complied with. If that's not you, then make sure you know who that person is. Also, I would say document your responses to your requests and make sure that as you document that you are you're prepared that if you ever get a challenge that you did not respond or you didn't respond appropriately, you have a place to go back to show what happened. So there's some key points that I also want you to remember just generally about communication, just generally about how you communicate. Please remember your written communications, your audio recording, all that you do in fulfillment of your work can become public knowledge. And I always ask our agency, would you be embarrassed if this was on the front page of the AJC or if it aired on the 6 o'clock news? Like, how do you feel about this being the way that you're being represented and your organization is being represented? And if there's a chance that you would be embarrassed or it would cause a little bit of a stain on how you're viewed, then maybe you want to approach this communication a little differently. Approaching the communication differently is going to mean that you're paying attention to what you say and what you write, because it also could be interpreted as not your personal opinion, but the opinions or the directions or the feelings of the entire organization. So we've seen this in the news pop up everywhere, especially with emails. People are being exposed for having things in their emails that are insensitive, they're illegal, they're immoral, they are, and they're really not fulfilling the workplace purpose. They're really generally something that could be interpreted as a personal approach or a personal assessment in the email. So we want to avoid doing that at all costs. Even when we're doing presentations like this one, we want to be mindful that what we're saying and in these recordings, we don't just speak for ourselves. So if you find yourself giving presentations and you're saying, well, personally, I feel, if that's a component part of how you deliver, you might want to rethink that strategy, because personal interpretations can lead to very, very big implications for your organization. So what you say and what you write can be interpreted as communications that are official. So here are a few more tips on how you avoid that. We just talked about avoiding interjecting your personal opinions and your personal decisions when you are doing so in writing or in recordings. That even means voicemails and also on external phone calls, because in Georgia, we are a one-party recording state. So if I'm talking to Jessica and I want to record my conversation with Jessica, I can do so. And I can then choose to do with that recording whatever I would like, because I was a party to that conversation. So interjecting your personal opinions could be risky. And I think this is especially important for a group like us, who likely interact with the public via phone all the time. So someone might call up to say, hi, Christy, I know that you typically are the one that's handling GORA stuff at DCA. And I had a GORA question in my area, but just real quick, do you think that this is even worth it? Like, should we be doing this? And I'm thinking I'm talking to a peer or a colleague, and like, well, you know, I personally really feel like whatever. And I give my personal opinions there, and that could even come back to be interpreted as something that was intended to be a decision or an opinion of my agency. So just be careful when communicating and interjecting personal opinions and personal decisions, not professional opinion or professional decisions. So that's the litmus there. If you're being relied upon as a professional, you can give professional opinions and decisions, and that should not be something that you feel that you should withhold. But on the other hand, if it's a personal opinion or decision, but you might want to avoid interjecting those. Also, if you're going to discuss something sensitive, it's a sensitive topic or sensitive information, and you don't quite have the direction that you're going to go yet, it's always best to do those directly. If you're down the hall from your director and your director needs to know that there's a major problem and you're trying to figure out all the options to resolving it, it's probably worth it to have a conversation with them first to lay out the framework. I am in no way saying that you shouldn't document how you are approaching issues when you're aware of issues and how you resolve them. But before you get to the point of being ready to put an official documentation down, sometimes you need to kind of data dump and just get into the meat of it with someone to organize your thoughts. And you don't want to use communication means to do that if you're not ready for that, because that can also come back to bite you. If you're communicating via email, chat, or text message, you want to limit the recipients on that list to just the people who need to be involved. I saw a meme at some point where people were talking about workplace pet peeves, and they talked about the person who does a reply all or the person who sends a message that's really targeted to one or two people to the entire department. That is not just a pet peeve. It really could be something that causes problems when we are responding to GORA requests. How this shows up and how this could be a problem would be if the request comes for Jessica's emails for the last 2 months, and Jessica was copied on 75 things that she had really no involvement with, and it looks like there are breaks in the chain where someone initially started, other people started to respond, realized Jessica shouldn't be on it, so they dropped her off. The person who started the communication added her back on, and she has a broken chain of communication. Just looking at that email trail from Jessica's inbox will look like aware of this issue, and nothing took place for 6 months, because the next email I saw in Jessica's, well, it wouldn't be 6 months because that wasn't the look back period, but however the time frame was, the next email I saw was significantly later. And that may not have been the full picture of how this matter was being resolved or how this process developed, because Jessica just wasn't an integral part in how this should happen. So before this starts, before you can get in a pattern of breaking chains of communication by having recipients in there that really shouldn't be, you want to consider making sure that you are deliberate about who's being included. Not to say you can't add people or remove people as their involvement allows, but just as a practice, you don't want to just decide you're just going to send it to everybody and let them choose if they want to be in this or not. You want to be more deliberate about who should be included on that so that you have less risk of broken communication chains that would show up in your open records responses. We've said this before, you want to make sure you're relying on your agency resources. If you have a communications team or legal team or just a professional in your organization who typically does that, rely on them to provide official correspondence or official communications. So that's not your everyday role. If you're not the person who's going to give the report on the fiscal changes over the last 30 days, if that's not what you do, then you don't want to attempt to make those types of communications in your communication streams. You want to rely on the people in your organization who are tasked with doing that thing. So that way, if there's a response or a request for records for that type of activity or that type of information in the records, then there's less risk of inconsistency because you've channeled that communication through one source. And then always ask questions. Excuse me, if you're unclear about the best way to document a very important decision or an important discussion, have a conversation first, make a plan, and then document based on that plan. That's kind of a piggyback to the very first tip that we had here. So that was my presentation for today. I hope that it has been helpful. At DCA, I do serve as our general counsel, but I work very closely with our office that does records management when it comes to GORA compliance. So if you have additional questions beyond this webinar, you can always reach out to me, and either I or someone else on my team will be reaching out to you in response with any help that we can offer. But are there some questions that we might have from the group?
Of course there's questions. I have my own that I want to just throw in here at the end, just because we were recently just talking about it. And so I think as a former Main Street manager, I understand that a lot of times people will just shoot you random emails, right? And ask for information. So for new managers who, may not know all the players within the city, may not know all the rules and policies, what are some good first steps for handling stuff like that? Like, before you respond, would you reach out to your boss at the city? Would you reach out to council? Do you just respond to it? Where do we begin with that kind of process to figure out if we're doing it right, how to do it? Should I just respond, or do you know what I mean? It can feel very overwhelming when you're new.
Yeah, that is a very tricky distinction, because we are working all day, every day. And so we can expect that there will be questions and inquiries. People might email you, they may call you, and they may ask for that. So I would say there are a couple of things that you should go about thinking through how to approach this, a couple of ways to approach this. So the first thing is, what's being asked of you? Is this within the course and scope of what you do all day, every day? If it's a request for a report, though, or anything that would be considered a record, you want to make sure that even if you informally provide it, that you're still doing that with the thought process in mind that this could have been a GORA request. In our agencies, where it shows up, we have a dedicated GORA process. So if someone were to reach out to a new manager and just make a request like that, I want to see the last 3 reports for projects that your office has administered. If that request came via email to a new manager, they could then say, we have a process for requesting records that's through our open records team. I'm forwarding your email to the gora@dca.ga.gov email account, so that we can get you in the right stream to get those responses to you. Even if I have the information that I can just share very quickly, it should be documented in a way, and we make sure at DCA that we advise our managers to do that. Now, the other part of your question was, how do you make sure that this is appropriate? There are some things that it's going to be so easy for you to just quickly provide, and some things that you may want to coordinate with your leadership above that. I always advise managers to look at what being requested, what is normal in the course and scope of what I do, or is there anything different about this request? So if I'm responsible for reports, and I'm doing the reports for compliance in whatever capacity, and I do these reports all day, every day, and my partners have asked me for a copy of the report, that might be within the course and scope of what I do. But when it shifts, and the question is, I see that you have the report for fiscal management of Region 9. I need to see any emails or what went into how you got to these final allocation numbers. Can you provide me with any background records of what led you here? Decision-based questions, anything that would go beyond the scope of what I was responsible for directly, I would want to have a conversation about that request with someone else, just to be sure that I understand the impact, and I understand if I'm thoroughly responding. I know what my universe would be, but I don't know if someone else in my department or my organization may also have responsive records. So there are a few different ways that you should approach that. But if you have any questions, I always say it's better to have the conversation before you release it. But I say look at what's being requested. If it's a record that you have immediate control over, you're the drafter or the person who maintains that record regularly, that can be something that can be released within the course and scope of what you do. But if by chance there's something unique about that, ask some questions, or even when you're responding that way, respond within the 3-day time period, because GORA rules still apply. Even if the person doesn't say, I'm making an official GORA request, we should always know that those GORA rules are there.
Mm-hmm. Awesome. And I think Christy, inadvertently hit on something really important, which is have these discussions prior to something like this happening, right? Like if you're new and you want to know, reach out, ask, so that way if something does come up, which I guarantee if you do this long enough, something will come up. But that way you feel prepared for it. And half the battle is just knowing how to handle something when it comes in, right? And making sure that we feel empowered to make, the right decision when it happens. And so I'm always an advocate for being proactive in stuff like this.
Very, very helpful. Be proactive and document. Those two things can help you very, very much.
Yeah.
Well, thank you for taking the time to be with us today. If you have any questions regarding this webinar or any other information from our office or the Georgia Department of Community Affairs, please feel free to reach out to our team at mainstreet@dca.ga.gov. And we'll see you next time.